Tim, can you make sure to turn your microphone on? Yeah.
There we go. Let's start over. We are on the record. This is the Appeals and Variance hearing. My name is Tim Pack. I'm the Appeals and Variance Hearing Officer. Today is March 31, 2026. First, approval of the minutes from our last hearing, January 9, 2026. I've reviewed those, and those meeting minutes are approved. Next item on the agenda is the Chris Gardner variance application. Before we begin, let's get everyone's appearance who would like to make an appearance, starting with the city.
Jennifer Jastrzemski.
Todd Draper. Spencer Duchesne, counsel for the city.
And Matt Symes, building official for the city.
Lori Stout, executive assistant.
Thank you. And now for the applicant.
Chad Hutchings, counsel for Mr. Gardner.
Chris Gardner.
Great. Welcome. Is it Hutchins or Hutchins? Hutchings. All right. And are you going to be speaking on behalf of the applicant today? Yes. Okay. Well, feel free to take the podium, and let's begin.
I mean, is this hot? Is this microphone on? Yes. Okay. So we have kind of stepped into this case, our firm, somewhat last minute, as Mr. Gardner's prior counsel is now a judge. So we have taken over this case from him. So I will be obviously dealing with the documents that were prepared by Mr. Whiting on Mr. Gardner's behalf. But I have not prepared any documents myself. To begin with, I would start with the assumption that you have read all of the documents that have been prepared by Mr. Whiting and by the city, so you understand each side's relative position in this. So I'm not going to belabor points or spend a lot of time reiterating everything that's here.
Yeah, you're correct. I've read everything that's been submitted. Thank you.
So what I would like to address are some of the important things that I see in this, especially from Mr. Gardner's perspective, and I would like to address, of course, the arguments that are made directly in the briefing from the city. I've made a few notes about that. What we are looking at is a request on Mr. Gardner's behalf to have the city allow him a variance on his building that the city says does not comply with its ordinance governing setbacks. The first thing I would like to say about that is, of course, Mr. Gardner, not being a contractor or an attorney or anything like that, hired somebody to do the construction for him and relied on that individual's knowledge and expertise as they were holding themselves out as a contractor to know what permits needed to be obtained and to know what building ordinances and regulations applied to the specifics of what wanted to be done. So, you know, it talks about this as being something that was done in ignorance of the law and brought his, shall we say, brought his misery upon himself. But the reality is the misery, if it were misery, were brought upon him by what turned out to be an unlicensed contractor. He did not know that, who did not follow the law. Again, he was relying upon the contractor to know his business and follow it. Ultimately to his detriment, even if it's only just having to deal with this hearing and these applications. What we are dealing with is not an ignorance of the law situation, but a mistake of fact. As attorneys here will know, if I'm going 45 miles an hour in a 40-mile zone, I get pulled over for speeding. I can't say, oh, I didn't know it was against the law to speed, but I can say, oh, I thought this was a 45-mile-an-hour zone, and as a mistake of fact, I'm probably not going to get a ticket from the police because they're going to go, oh, well, we probably can't win the oops, I thought it was something other than what it is. We're kind of dealing with that same sort of situation here. So when we talk about the unreasonable hardship aspect of this, the city's council would like you to believe that this is a self-imposed and economic hardship. Was not self-imposed in as much as he was relying on an expert, or whom he thought was an expert, to do his job correctly. And as for economic, yes, there is some economic hardship here. He has saved up a great deal of money for a great deal of time in order to fulfill this dream. So there is that economic aspect, but there is more than just the economics to it. There is the fact that he had fulfilled a dream, and suddenly comes to my mind the poem from Langston Hughes, "What happens to a dream deferred? Does it dry out like a raisin in the sun, or does it explode?" Sometimes a dream that goes unfulfilled makes greater hardship. Now, I'm not meaning to imply here at all that he might go off the rails in some violent way with the explosion, and that was just a quote that just came to mind. I was an English major, so I read a lot of poetry in college. But just the fact that sometimes the dream deferred can become something that harms the dreamer. When you lose your dream, your sought-for goal, sometimes it causes a person psychologically to turn inward upon themselves. And in the case of Mr. Gardner, we have documentation from his therapist that he's already dealing with some pretty significant post-traumatic stress from his time in military service. So I am concerned of how this might inwardly explode upon him. That is part of the hardship here. And of course, that's also goes to other reasons for this variance to be granted. There's also the fact that having, this is not, say, for example, say a trampoline or something that he can just, or a shed that he can just pick up and move a few feet. If this variance is not granted, he will have to demolish the building, also at expense to himself, and then perhaps if he feels he needs the same building, try to rebuild in some other way on the property in compliance with these variances, which would ultimately more than double the cost that he's originally put into this. Now, some would argue, well, okay, that's an economic loss. He can go after his contractor. Well, I spent the first half of my career as an attorney doing subrogation work for insurance companies. For those who are not familiar, subrogation work is insurance, say, for example, contractor doing work on your house, sets fire to your house, you call your insurance company, they fix your house, and then the insurance company would hire me to go recover out of the contractor for the damages that had been done to the home from his negligence. I learned from sad experience doing subrogation work that unlicensed contractors don't have any money to go after, and you get judgments, sure, that you can frame, because that's all they're good for. So my concern is here that if we say, well, he can go sue his contractor, well, great, he can go get himself a piece of paper to put on the wall in his house and look at and cry, because it's not going to be any value to him otherwise. Special circumstances are one of the issues. Well, the special circumstances here are that we are dealing with a building that he built to help in his therapeutic process. Now, the city says, well, there are lots of other people in the area that could conceivably have the same or similar mental health issues, and they don't need these buildings. Well, no two people with mental illness or mental health problems have the same problem, even when they have the same problem. I can, give the example of I have a stepdaughter and two nephews who are all three on the autism spectrum, but no two of them are the same autistic. Just so no two people with post-traumatic stress disorder have the same presentation of post-traumatic stress disorder. So this outbuilding that he has had built on his property is there to help him deal with, treat, and hopefully ultimately overcome, or at least live with successfully, his PTSD. So that is a special circumstance in the sense of he's not special for having PTSD, because lots of people have that, but the building is special circumstance to the treatment and care for his unique situation. There is an argument about the right of possession and control of property, and you have seen, I'm sure, his dismay that he's being told that he cannot do with his property what he would like to do with his property. There should be some deference, though, to an individual's desire to have whatever structure they need on their property without getting too concerned about does it meet the exact letter of the law. And that brings me to the next point about the Draper City General Plan and how this building in the city's view does not conform with the general plan of the city. And there is talk in the brief about the semi-rural nature of Draper City. And I don't mean to disparage Draper City. I grew up in Sandy in the 70s and 80s at a time when Sandy was a lot more rural than Draper is now. And I remember coming down to Draper. I had friends down here. I remember when 7th East ended just a couple of blocks past 126 here. And I remember when it was mostly farms. The nature of this place, though, and I came down here today, my office is in Lehigh, I came down Fort Street. I remember when Fort Street was farm, 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 house, farm, 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 house. And now it's house, 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 house. I mean, they're enormous houses, but they're houses. Most of the farms are gone. And, you know, I'm not saying that's a good thing or a bad thing, but that's the fact. And I mean, I can remember, I go down 7th East, go to my parents' house. I go down 7th East all the time, and I go, well, I remember that was Pearson's farm, that was Matsumori's farm, that was Lundberg's farm, that was Malmberg's farm. But now that's Marco Brown's office. Now that's a bank. Now that's a 7-Eleven. Those farms are gone. Those people are gone, and the nature has changed. Now, having said that, if you look at the overhead satellite view of this neighborhood, and I'm sure you've seen those photographs and those images, we are dealing with some reasonably large houses on some not very large parcels of land. We're talking about 1/3 of an acre, not quite 1/3 of an acre on the parcel of land that his home is on. I can't imagine a definition of property or of a city that would say that 1/3 of an acre is semi-rural if you have a house on it. And if you look at the overall nature of that particular neighborhood, we are dealing with what I think most people would describe, without knowing anything else, as a straight-up suburb. Houses in a neighborhood fairly close together. Some people have sheds, some people have pools, some people have other things. Some of the photographs that have been provided also show that some of the neighbors in that area, not exactly his direct neighbors, but some of the other houses in that area, have even larger outbuildings on the properties. So his outbuilding isn't even that big of a deviation from what's already there in other parts of that part of the city, as well as, I'm sure, other parts of Draper City in general. And some of these other outbuildings
Can I ask you about that real quick?
Yes.
So in the materials, I see a couple of aerial photographs.
Yes.
And it's not necessarily the neighborhood. Maybe it's just sort of the adjacent properties around Mr. Gardner's home. Is that right?
I know those have been provided. I know there were others. Maybe you don't. Maybe some. I've got them here on the desk if you want them.
And there's a photo. I mean, there's a photo also from the main house. Is 11674 South Douglas Vista Drive. Mm-hmm. Where's that in relation to the subject property?
I don't know the answer to that question. Do you know where that property is that he's asking about?
11674 is my property, and I submitted a photo of the structure, the additional structure. Maybe that's what you're seeing. Some of the...
Okay, I'm sorry. Sorry, that's right. That is your property. So there's one photo with, it's 11324, page 26 of your PDF that you submitted.
You said 11324?
Yeah. Can you-
Yes, I do have that photograph.
But whose home is that? Is that near?
Tim, is it this?
Yeah,
image?
this is the
Yeah.
one I'm looking at. Is that meant to depict one example of a rather large accessory
I would say
building
that
that's
is
less than 10 feet from the property line?
Yes, I believe that is a example of, shall we say, a non-conforming use that was provided by Mr. Whiting. I kind of went on the assumption that that was provided and that he had explained carefully enough where that was and what that was. So
If
I
I may,
apologize.
I think there were several other examples that were in Draper. That one must have been an one-off since it's South Jordan.
So from the photos you've submitted, how many examples of accessory buildings are there
I'm not
that
exactly
don't comply?
right. I don't know exactly how many photos Mr. Whiting submitted, so I can't answer that question intelligently. I'm sorry.
Okay. Sorry to interrupt. Keep going.
No, you're fine. No, I want to answer your questions. That's the important part.
One addition, I apologize. From what I saw that Mr. Whiting had there were also homes themselves that were not following the Draper setback. They weren't even 10 feet apart from each other. So, and I guess Mr. Whiting assumed that the city already must be aware of those instances since they have nothing to do with sheds or anything. They're just homes.
Now, I noticed this photograph, and there's something on here that I noticed when I was looking over these documents when I got them last week in anticipation of this hearing. And you'll see at the bottom there, those property dimensions. Those are the dimensions of the overall lot, not the building. Because, I mean, those dimensions are basically half a football field.
Okay.
So I got confused at first, too, when I thought there's no way this building is 153 by 106. And did clarify, we are dealing with a building that is something just over 400 square feet in area. This is an older satellite view, I know, because obviously it does not show his outbuilding in there. And I did go to Google just last week, and it still doesn't show his outbuilding on there. So they have not updated their satellite imagery in the time since the building was built. Unless, oh, well, they have now. It wasn't there last week.
This is the city's map. We just a few months ago got an aerial from 2025.
Okay,
So
because I was like, that was not there last
It's very
week.
recent that we've had access, so.
So you will see from this image, we're not dealing with a terribly large building. It's nothing that's visible really from the street. And it is something that he has talked to his neighbors about. None of the neighbors are bothered by it. In fact, some of the neighbors really like its existence and feel that it actually increases their privacy and their enjoyment of their property. So that brings me to kind of what I would say is an important question in my mind as I've been going through all of this. Where's the harm? Who's being harmed by this building? I know that's not something that's outlined in the statute, and it's not something that's contemplated in the case law that council has provided, but I think that is the overarching question in all of this is, where is the harm? Who is being harmed by this building? None of the neighbors are being harmed. They're not complaining at all. In fact, they like it, or they're fine with it at the very least. So none of the adjacent property owners have any complaints. you can't say that you drive down the street and see this eyesore because it's hidden by the house. If it's changing the semi-rural nature of the area, well, I mean, again, I look at this and see suburbia, not semi-rural. If we say that it's, I don't even know, I can't even postulate any other harms that would be out there. What I do see is a potential harm, and not just a potential harm, but a very real harm to Mr. Gardner if he's compelled to bring this down. And in multiple ways is he being harmed if he's compelled to bring this down. So those are the things that I would address. Those are the things that I feel are the most important things from Mr. Gardner's perspective. Do you have any questions for me specifically?
No, I don't.
Okay.
Thank you.
Do you want to hear from Mr. Gardner individually, or?
There's a statement from him that I've read. I've read all the materials. If you'd like to, you have an opportunity. But know that I have read everything, and I think I understand everything. But this is your time, and you're welcome to speak.
Do you want to speak at all? You can stay there. Push your microphone down, though.
I wasn't necessarily planning to speak, but I feel really bad about all this. I haven't been able to sleep for the last year. It's just, I don't want to make excuses for myself. I'm happy to pay. I'm happy to work harder, to pay whatever I have to help, to do something good for the city. My condition leaves me dealing with a lot in my head. And so these kinds of external things, I do my best, and I'm lucky that I have a very profound working memory. I can handle a lot in my mind, and so I can present here today, semi-normally, but the truth of the matter is I don't have a normal existence. I have severe problems mentally, and it's all I can do to try to forget about my problems and to try to help other people, because that's all that matters. I have a son. He's 2. I didn't plan on that. My condition, I didn't think I should ever have a child, but despite contraceptives, we have a beautiful little boy, and it's all I can do to try to provide for him and to do the best I can to have a family, to make my soon-to-be wife happy. And I wanted this building to be multi-use. I first had it built after having dealt with a flooding swamp issue in my yard, that corner, because of the way that area is supposedly was always a very bad flooding area. So they had to put I think it's called a French drain around my property. And what that does, as far as I understand, someone might understand better who deals with construction, it pushes the water that's kind of there too close to the house. It like makes it go into I think the northwestern corner, which is where that structure is. So it was always swamped out back there, and it caused a problem for my neighbor to the north, Mike Chenoweth. And he had the swamping issue because of that, because he didn't have a French drain. They didn't put one in. His house was built before mine. But then once they realized they had legally an obligation to put it in my property and some of the other ones, all this to say, I had to ask some experts. They said putting in gravel and concrete back there would help. And there is a corrugated pipe. It's very big. I don't know what it's called, but goes vertically down at that spot so that I can pump the water out. And so the thing to have a pump out there, the builder provided piping for electricity. That was already provided in the initial build and with the mortgage and whatever you call it, beyond permits, it was already there. And so I put that in, and then my neighbor to the west, David Charette, he built his shed first, and neither of us knew that there were these codes. In fact, the city wasn't sure on I know there's two issues, on the issue of two buildings being too close to each other, not just the setback, but anyway, there's a lot of things going on there, but all this to say, I was trying to, I painted that court. It's all dilapidated now, you can tell, because I clearly don't know what I'm doing. I went to Home Depot, and it's all falling apart already. It's kind of like my life. But I was hoping the neighbors, they could come by and play and go, they would use the facilities. And I have a guy that's older guy, and his name's Paul. He can't afford to live anywhere. He's an inventor, and I was letting him use that spot back there. He was doing some inventions. He's had patents stolen from him, and I guess I felt bad for him because I thought, man, this he doesn't get the external world. He doesn't know how people work, the reality, and I felt for him because that's how I am. Anyway.
So, thank you.
Sorry.
No, you're good. I would point out two things from what he has mentioned. It is important to point out that the electricity was already there. They didn't have to run additional power for that. And the drainage was already there. There wasn't additional sewer plumbing that had to be done, as far as I'm aware. Maybe just hook up to the already existing sewer on the property. But the overall construction of the pad and then ultimately the building has mitigated flooding problems for Mr. Gardner and his neighbors. So that is another benefit that I would point out, is that this structure actually provides, whether it was built to do that or not, it does provide mitigation and prevention of flooding in that area for those people. This is, if you zoom out on the satellite view, you can see that this is on the west side of the interstate, and not too far from the canal there and the river, and in the floodplain. So mitigating flooding for himself and his neighbors, I think, is also a valuable service to the community. And I would argue that is a special circumstance for this building, and also a special circumstance to consider why the variance should be granted to continue that benefit that is provided to himself and his neighbors.
And I'm sorry, so are you saying the construction of the building itself and the drainage around it has mitigated flooding that would otherwise occur?
Well, the original pad started that, yes, and I think that there's an argument to be made that the building has furthered that.
Okay, I understand. Thank you. And I'm sorry, tell me your name one more time.
Chad Hutchins.
Hutchins, thanks, Chad.
H-U-T-C-H-I-N-G-S.
All right, thank you, Mr. Hutchins.
I don't mind spelling it. I do it all the time. It's this purely English name that no one can say right or spell correctly.
It's pretty, I got it.
It's spelled exactly how it's said, so I'm just used to it.
Okay, I got it. Thank you. Mr. Duchesne? Whatever you like. You're fine from there.
Okay, so first off, these hearings are somewhat difficult because I don't think that there's a great understanding of what a variance is amongst most people who are not sophisticated in this area of the law. A variance is an extraordinary remedy that requires extraordinary circumstances. They should be rare. Variances within the state of Utah are so rare that there are only a handful of cases that address a variance wherein a variance is granted and upheld. Speck versus Big Watertown is probably our most demonstrative case that we cite to the most frequently in the world of land use. I've drafted the brief. I'm assuming you've read that. Just wanted to respond to a few things. Certainly the city is not unsympathetic towards Mr. Gardner and his struggles. Certainly we have a great deal of sympathy for all of our citizens and for the hardships that they have. Wanted to respond to a few things that Mr. Hutchings said. We understand that there are people who will hire non-licensed contractors all the time. The remedy for that kind of a failure is not necessarily to come to the city and ask for an extraordinary remedy, because again, it's not an extraordinary circumstance. That remedy is to go after the contractor, and like Mr. Hutchings said, sometimes that doesn't always work out. But the city is not in the position to be bailing out citizens when they get things wrong with the contractor. City is not necessarily opposed to a building. It's merely opposed to the encroachment into the setbacks. We enforce this wherever we can. One of the problems that we have is that we do get a lot of complaints about, oh, well, you didn't enforce it with them, so why are you enforcing it against us? Well, to respond to that, a lot of the buildings that have been cited in Mr. Whiting's brief and that we've looked at are under 200 square feet. So sheds and outbuildings that are under 200 square feet aren't required to meet the same setback standards, and that's under our own city code. This is well over 200 square feet, this building. So we're going to require that it meet the setback standards. When we talk about special circumstances, and we talk about when we talk about all of the elements that are required for a variance, all of the elements that are required to meet a variance attach to property and not necessarily people. And the reason for that is a good reason. The policy purpose behind that is property stays forever, and people come and go, and they occupy the property, and then they don't occupy the property. And we certainly hope that Mr. Gardner wants to spend a great deal of time in the city and wants to be one of our citizens for a great deal of time and for his long life. The problem is that eventually everybody leaves this earthly plane and somebody else is going to occupy the property later. Same can be said with the neighbors. The neighbors might not have a problem with it now, but subsequent neighbors might have a problem with it. Or when the neighbors who don't have a problem with it now are looking to sell their property, potential buyers might see that building and say, yeah, I don't want to move into this property because there's a building that's 14 inches from the property boundary line, and I don't want that close of a building next to my property. So we should be looking at these 5 elements for a variance as they relate to the property, not to the people. So extraordinary circumstances, sure, people's mental health struggles might be different from one person to the next, and everybody might need a little bit of a different purpose or a different way to cope, or a different means of therapy, and we're certainly not opposed to that. The city's full on welcoming of Mr. Gardner having a building in his backyard, an accessory building, but just insofar as it meets the requirements of our ordinance. The other problem that we have with the claim that the city doesn't enforce the ordinance is if we allow an ordinance to go in force now, then somebody coming in later and trying to do something similar when we go to enforce the setback ordinance elsewhere will say, well, you didn't enforce it with Mr. Gardner. Why are you enforcing it against me? So we're going to have that complaint again and again and again. And beyond all of that, there's a case out of Summit County, it's Burmese versus Summit County, that says a city's failure to enforce its ordinance in the past does not preclude its ability to enforce its ordinance in the present or in the future. So if there are buildings that violate the setbacks in the same area, our failure to enforce previously does not mean that we cannot enforce now. When we're talking about our general plan, I actually completely agree with Mr. Hutchings that Draper is not semi-rural. However, our general plan identifies that area as a semi-rural area, and until our general plan changes, we have to evaluate this prong of the test under what the general plan calls for. And so we have to look at the facts. We have to look at our general plan that says that semi-rural is this area. And then we have to evaluate whether this building fits within the general plan, and we think that it does not. When we're talking about substantial property rights, there's competing thoughts about substantial property rights. There are some people who believe that I can do anything that I want with my private real property. And we've kind of rejected that notion as a nation within the law. And then there's the other extreme opposite end of that, and that is kind of like the HOAs on steroids, I'll call it. We get to tell you everything that you can do or can't do with your property. And I would look at zoning laws and land use laws as somewhere as a happy medium in between. We are in 2026 at the 100th anniversary of Euclid, which was a land use law case that upheld that substantial property rights aren't necessarily infringed by zoning and land use regulations. So it's well established that we can enforce a setback or we can enforce zoning laws, and that does not interfere with somebody's substantial property rights. We have a situation somewhere else in the city, and I won't be too specific, but I'm sure you're aware of it, where a gentleman has a legal non-conforming building that encroaches into what the setbacks are now, and he has built additions onto his building that further encroach in the setbacks, not necessarily going closer to the property line, but going higher and encroaching into the setback more because it's more of an encroachment going vertical as opposed to closer to the property line. And in that situation, we do have a neighbor who was the previous owner of the property was okay with that building being so close. And the neighbor now is saying, we don't like it that close. We're losing potential buyers because the building encroaches on the setbacks. And why won't you enforce your ordinance? And so we come up against this a lot as a city, and we're trying to enforce where we can. We're certainly glad that Mr. Gardner is part of our community. We're certainly glad that Mr. Gardner has found a building that, has built a building that helps him to live a better life. The unfortunate thing about the nature of a variance is it's not about that. It's about the proximity. It's about property. It's not about people. It's about land and buildings and where they are. So, this is one case where we would be fully supportive of Mr. Gardner moving his building to match the setbacks. And we would be, as a city, okay with that so far as it meets all the applicable zoning and land use laws. I recently had an opportunity to chaperone my son's band trip in Boston. As part of that trip, we went to the Louisa May Alcott House. And on the first part of the tour of that house, we went into the kitchen of the Louisa May Alcott House. That building, that part of the house was originally an outbuilding. They had their kitchen away from everything else. And the family decided that they wanted to bring it closer to the regular house, and so they rolled it down on logs. And I was thinking of this exact situation, and now we're not asking Mr. Gardner to roll something on logs. We have a great deal better technology, but we would require it to be moved as an enforcement of our zoning ordinance. The city doesn't think that Mr. Gardner can meet the burden of showing that all 5 criteria under the variance statute or the city ordinances have been met, and for that reason we would ask that the variance is denied. Do you have any other questions for me?
No, thank you, Mr. Duchesne.
Yep.
Mr. Hutchins, anything further from you?
Well, the one thing that I would say in response to what has been presented is that my client does say, which I think is somewhat obvious based on the drainage issues that we've discussed and how the plumbing was done there. This building, it can't be moved. It's either remains with a variance or it's demolished. But it isn't, like I said, it isn't like a shed that you put in your yard to put your tools in or your snow blower when you're not using it. This doesn't just lift up and move or even be put on blocks. And I guess I wouldn't say that it can't be moved because, those of us who've been around in this part of the valley long enough remember the Victorian house that used to be on the corner of 7th East and 86 South, which is now up about 12th East and 86 South. And it was moved. I remember when they moved that. So yes, building a house can be moved, but the cost of moving it would be greater than the cost of demolishing it and rebuilding it, I suppose, and would be either way prohibitive. The city, makes arguments about, well, the current people are okay with it, but, some future potential buyer may not be. Well, all I can say to that is we can sit here and speculate all day about what somebody may or may not do in the future and whether or not a variance should be allowed or disallowed based on the speculation of what some hypothetical person in a hypothetical future, that shouldn't even be considered because we don't know. We could find any number of hypothetical situations where the person could come in and say, wow, this is great, I love this. Likewise, Mr. Gardner did point out to me when council was speaking about the fact that, he has no intention of relocating from this property for the remainder of his life. Obviously, there will come a day when he will leave, whether it's voluntarily because involuntarily because he's unable to care for himself or involuntarily because he's dead and he's taken out by the funeral home director. But either way, yes, there will come a time when he's no longer there and some new party will take over the property, and maybe they don't like this building. That's part of buying a house. You buy houses, you get a shed on there. I don't like this shed. I don't like this outbuilding. I don't like this gazebo. You tear it down. That's part of it. Or you say, well, I don't really love it, but hey, I can live with it, and you buy it anyway because it's the right price. So again, these hypothetical futures really should not be taken into account when we're dealing with the reality and the known quantities of today and the facts as they affect my client today.
Okay. Let me just ask you one question. So let's say that Mr. Gardner hired a contractor who knew exactly what the setback requirements were. Was there any condition related to the property that would have prevented a contractor from constructing the building in accordance with those setback requirements? Could it have been done according to the city's regulations?
Right. I mean, I've not researched that question. From what I have from Mr. Whiting, I don't think he researched that question. I mean, if you look at the property, I would say that theoretically, a structure that met this purpose with the same contents but not the same floor plan could have conceivably been constructed somehow on the property within the setbacks, and we wouldn't be here. Is there a reason why it had to be built in that specific spot? I would say no, but there was already a concrete pad there that was not otherwise useful because it had to be a concrete pad there because of the drainage issues. So I would say, this is me talking, this is not Mr. Gardner, this is obviously, I've never even met his contractor, but I would say, you know, if it were me, I'd be, well, why not build it there? Why not have it there? And there's already a guy's shed there, so I'm not blocking his view of anything because he's got a shed. He's not going to be looking at the back of my building. He's looking at the front of his shed, so why not? And I would also say that, you know, again, had he hired a licensed contractor who knew all of this, that contractor would have done it correctly and would have found the solution that met the variances. And again, we wouldn't be here. And if that contractor were licensed and hadn't somehow met the setbacks, well, then that licensed contractor would also be bonded, and he'd have a recourse that wouldn't be a waste of time and money.
Okay. Thank you.
I think he has something that he'd like to say, Mr. Gardner.
Sure.
Apologize. I have sympathy as well for some of the arguments that Mr. Duchesne made, and I've already thought about it, which is why me and my neighbors have put some trees in certain places because everybody likes privacy. So I suppose the only remaining view is the bird's eye view. You know, at some point you obfuscate such that you're not intruding. They're like columnar trees, and they create a sort of very high wall. Something you can't do with a fence because it's not authorized, obviously, and that's unsightly. But the trees are not. They're beautiful, and that's the point of them, as far as or part of the point at least. The beauty, the fact that it helps to create that sanctuary, not only for me and my family, but for everyone else too. And believe me, if I knew somebody was having a problem with it, I would talk to them directly. I would try to work something out. I have my own theory as to who. Yeah. Anyway.
No, I don't think there's any doubt that it's a very nice building. It looks very nice on the property. That's what I say. So, the city's correct that variances they're very hard to obtain. And as the appeal officer, my hands are really, I'm really handcuffed. I can only grant variances in very limited circumstances. This is a very, very hard decision. I'm going to consider the documents again. I have very detailed notes. I consider the arguments that have been made by both sides, and I'll issue a written decision in the next week. It's okay. But good luck to you. Thank you for your time.
Thank you.
Thank you, everybody.
Do you need my email address? I know Jennifer has it. She's corresponded with me to make sure I had all the documents, but do you need it?
So when I issue the decision, I send it first to Jennifer, and then she sends it out to the
All right, fair enough.
parties.
Thank you.
Okay. Anything else?
No, I think you just need to close the meeting.
All right. The meeting is closed. Thank you, everybody.